Hello and welcome to a special interview for The Wire. The National Register of Citizens has been published in Assam and it raises deeply worrying legal and constitutional questions about the way it's diminished the concept of citizenship and in turn what impact that would have on India's valuable democracy. But the bizarre part is questions about this have hardly been asked. Some cases they haven't even been asked at all, and when they have been asked, they certainly haven't been answered adequately. So with me today to shed light on this entire gamut of issues are one of India's top experts on the Constitution, the Vice-Chancellor of the Nalsa University of Law, Faizan Mustafa. Professor Mustafa, let's start with something that actually most people aren't even aware of. The National Register of Citizens in Assam has been drawn up in a way that actually breaches the Citizenship Act of 1955. The NRC uses as its cutoff point for citizenship midnight on March the 24th, 1971. But the Citizenship Act is absolutely explicit. It says every person born in India before the 1st of July 1987, in other words, up to the 30th of June 87, is a citizen by birth. And the Citizenship Act is the law of the land. So doesn't this mean that the NRC has violated the law?
This is how I would like to think so, that NRC is in clear violation of Section 3, which gives citizenship by birth. And since NRC is being done under the rules for Register for Citizenship and National Identity Card, rules cannot violate the Parent Act.
So you're absolutely clear that the NRC violates the Citizenship Act? Because this is a very important statement, so I'm getting you to repeat it. You're clear about that?
I'm clear about it.
Let's then go into this in some detail because I think it's a very important point. Pradeep Hajela, the coordinator of the NRC, has said, citizenship purely by birth and not by descendants is not eligible for inclusion in the NRC. And his reason is that one parent of such people could be a doubtful voter, a declared foreigner, or someone whose claim for citizenship is pending before a foreigners' tribunal. But the Citizenship Act Section 3(1)(a) clearly says, and I'm quoting, every person born in India on or after the 26th of January 1950, but before the first day of July 87, shall be a citizen of India by birth. Nowhere in that section do they talk about the parents of such people. Nowhere do they talk about the citizenship status of such people. So my question is simple. Do you believe Mr. Hajela's reasons for arguing that citizenship by birth doesn't make you eligible for inclusion in the NRC are valid reasons?
Laughable. You yourself said that Section 3, Clause 1 says anyone born between Republic Day of 1950 and 30th June 1987 shall be citizen by birth. Word used is shall. Shall in law means mandatory, while Hajela is saying could be a D-voter or possibly a foreign national. Just because Hajela thinks that there can be a possibility of their parent not being Indian citizen, he cannot be denying citizenship to anybody or inclusion in NRC.
So the word shall takes complete precedence over any doubt that is associated through the word could with the parentage or the citizenship of the parents of such a person.
In any case, could is a statement from NRC coordinator. It is not a statutory word. Shall is the statutory word.
So in other words, Mr. Hajela has no business overriding the Constitution or the law of the land. And the Citizenship Act is the law of the land.
Absolutely, because Section 3(a), which is giving citizenship by birth, is consistent with constitutional vision of just solely which gives citizenship by birth.
Now, in fact, the Citizenship Act itself explicitly says which category of people do not qualify for citizenship by birth. And according to the Act, only two categories of people don't qualify. Firstly, children of diplomats, and secondly, children of enemy aliens, provided they are born in a part of the country that is at that time under occupation. None of those categories apply to Assam.
Yes, but it is common sense. Embassies are floating island of the concerned country. So if citizens are bound to diplomats, they will get the citizenship of their parent country. And of course, we can't be giving citizenship to enemy alien. So if some countries at war with us, we can't be giving citizenship to their children.
But only those two categories are excluded.
Yes.
So when Mr. Hajela creates other exclusions, he's going well beyond the stipulation of the Citizenship Act.
Of course. And also he is in violation of several international conventions, which say Convention on Rights of Children, to which India is a signatory, which say that every child on birth will have a right to nationality.
And he's breached that as well.
Yes.
In fact, he's therefore not just in violation of the Citizenship Act, he's in violation of many international conventions that India has signed up to.
Yes.
Now, all of this was raised in front of the Supreme Court, and initially on the 9th of August, that's just about a month ago, the Supreme Court gave a categoric assurance that anyone born in India before the 1st of July 1987 would not be excluded from the NRC. But then 4 days later, on the 13th, when the Supreme Court gave its order, it argued that because the NRC had been done on the basis of 24th March 1971 as the cutoff date, the same cannot be now ordered to be reopened by initiation of a fresh exercise on the strength of the provisions of Section 3(1)(a) of the Act. What do you make of that explanation? To me, it suggests that the Supreme Court has given priority to administrative convenience over fealty to the law and over the rights of the people affected.
Under our scheme, Supreme Court is guardian of people's rights. Therefore, Supreme Court has been given the power to strike down a law which is unanimously passed by the Parliament if it is in violation of any fundamental right. Administrative convenience is not a justification to take away the most fundamental of all rights. Citizenship is a right to rights. If you have citizenship, you get other rights.
This is very important. The Supreme Court is the guardian of rights, yet here the Supreme Court has actually gone the opposite way. It's agreed to Mr. Hajela, who's undermining rights. So then it follows from this, and this is very important, that in this instance, the Supreme Court has not only permitted, but worse still, it's protected Mr. Hajela's arbitrary restriction of the concept of citizenship.
But that is the story of NRC in India has been in last few years. Starting from Sonowal's judgment, where court itself is taking over the role of the executive. What was challenged in Sonowal's judgment, and he is now the Chief Minister, was the IMDT Act, Illegal Migrant Determination Act. Now, when the constitutionality of a law is challenged, the job of the court is to see whether Parliament had the power to pass that law or whether that law violates any fundamental right. Court does not do this exercise. It says that illegal migration is aggression, external aggression. And if center is not stopping it, then it is in violation of its duty under Article 355, and therefore court struck it down. Striking down of IMDT, I think, was the starting point of today's crisis, and it was court-initiated crisis.
So you're saying a very important thing. You're going back in history and you're saying from the moment the Supreme Court struck down the IMDT, it has not only been exceeding its jurisdiction, but in addition, it's been tampering with the concept of citizenship itself.
Yes, of course. In fact, our Parliament has also been diluting the idea of citizenship, and our court has been supporting and taking several steps ahead of Parliament. You see, when government does any wrong, we go to the court and get it rectified in judicial review. Entire NRC process, court itself is taking decision which document will be permitted, which document will not be permitted. Where do people go then?
Therefore, in this particular instance, and I'm emphasizing it, rather than say to the NRC process, this is a violation of the Citizenship Act, and therefore it is a violation of the law of the land, what the Supreme Court has done, and remember, it did it as recently as the 13th of August this year, the Supreme Court has permitted a violation of the Citizenship Act, and then it's protected it, and it's protected it on the grounds of convenience. This is a particularly bad moment for the court.
Of course, in several other matters, we are presently observing that the court is not showing the same amount of commitment to protect people's rights and fundamental freedoms, which constitutionalists are not very happy with.
And the way the court has behaved over the NRC and the
Is
fact that the NRC
worrisome.
breaches citizenship is worrisome. But actually, it's a derogation of the court's duty. It hasn't fulfilled its duty.
No, what court did, they referred it to the constitutional bench. Now, if tomorrow the constitutional bench strikes it down, the entire exercise is to be done again.
But the funny thing is, on a matter that is so straightforward, they've referred it to the constitution bench and therefore, in a sense, passed the buck to the future. But they've permitted the NRC to carry on. And that process of the NRC carrying on could lead to people being declared illegal foreigners and stateless. In fact, I want to come to two very important consequences of what the court has done at this point. The first is, it seems to me that in our rush to conclude the NRC and in our rush to identify what we call illegal foreigners, we've adopted a process whereby legal citizens have been transformed into illegal immigrants.
Correct.
You'd agree?
I agree, yes.
NRC kind of exercise may be good for a small city state like Singapore. Here you are dealing with some 4 crore people almost. And therefore, when you are determining people's nationality and citizenship, fairness rather than speed should be the concern.
And here, because of speed and because of the process, we've ended up converting legal citizens into illegal immigrants, and that is doing them an injustice, it's unfair, and it's also illegal.
It's self-inflicted wound in which court is also a party, because in a matter as important as this, it should happen by this date should not be our concern. Our concern should be, it should be justly and fairly, and it should be done in most reasonable manner.
However long it takes doesn't matter. What matters is it should be done justly and fairly. But if you put a deadline, you're almost ensuring it will be done unjustly and unfairly.
And interestingly, the government was not in that hurry. Government was requesting the court to extend the deadlines.
The hurry came from the court.
From the court.
Which means that the court is guilty of two things. One, permitting and protecting infringement of the Citizenship Act, which we pointed out. But secondly, of ensuring that the whole process would be unfair because they imposed a deadline, and judges should have known that in a matter like this, a deadline is invidious to justice.
Correct.
So the justices have not acted in their wisdom, they've acted in haste, and therefore they've acted wrongly.
I would say that in this matter, what was expected from the court has not been delivered. We expected the court that they would ensure that people will not be denied citizenship if they have genuine documents. People are becoming stateless because there is a strict timeline set by the court.
Let me then come to a second and perhaps bigger consequence of what the court has done. Would you agree that the NRC process has actually ended up undermining, diminishing the whole concept of citizenship in India? And if it's done that, does that also have serious implications for India's democracy?
Current citizenship is idea of exclusion. Citizenship is not about people, it is about state. It indicates state relationship with people. Ideally, we should have civic nationalism rather than ethnic nationalism. The whole process of NRC, in my opinion, as you rightly said, undermines the idea of citizenship by birth, which is a liberal, universal idea. We are going for the idea of citizenship by relationship, which is a regressive idea in my opinion.
You said a very important thing. You began by saying citizenship regulates the relationship between an individual and the state. And if you tinker around with that term citizenship, then you're also ipso facto changing the relationship between the individual and the state. And in this instance, by excluding citizenship by birth from eligibility to be part of the NRC has changed the relationship between the individual and the state.
NRC has damaged our international reputation as a civilized nation. There are concerns expressed in international newspapers. People are worried what is going to happen now to 2 million people. Last year it was 4 million people. And therefore, I feel that the whole idea of NRC itself is a flawed idea.
No doubt it has damaged India's image internationally. But I would say to you the more important thing is that the NRC has changed the very meaning of citizen of India. It's now thrown into doubt that you can be a citizen of India by birth. The NRC has put a huge question mark over it, and many people who are citizens by birth have been deliberately excluded, not accidentally, deliberately excluded from the NRC. Yes. You agree?
Last year you had 4 million people. For last 1 year, 20 million people who are now included, they were living in panic and in fear, and they were expecting all kinds of harassment from fellow citizens.
And when you therefore arbitrarily change the meaning of the concept of an Indian citizen, are we doing damage to Indian democracy?
No, what really happened, that the way the argument was developed initially by ASU and subsequently, adopted by BJP was this, that this cancerous growth of, as Governor S.K. Sinha will put it, of illegal immigrants are undermining our democracy and they are affecting the outcome of elections. That's why the whole concept of de-voter came in. But now we know that these people are less than 6%, and after verifications and tribunals, this and that, at the end of the day, you may not have more than 3 lakh people. So there is no threat to Assamese culture, Assam's ethnicity, and these people in no way can damage the democratic rights of people of Assam.
And yet the situation we've reached today because of the NRC is that India today is a democracy where the definition and meaning of an Indian citizen is suddenly in doubt.
We are suspecting our own citizens.
And that is a terrible thing for a democracy to do, because it means there are some citizens you're not treating equally.
It's the worst thing to happen in any democracy, that you suspect your own citizens and then you create hierarchy among citizens.
The worst thing that can happen in any democracy.
Yes.
So far, Professor Mustafa, we've discussed how the NRC breaches the Citizenship Act. And the Citizenship Act, by the way, is the law of the land. We've discussed how this has been not just permitted but protected by the Supreme Court. And then we've discussed what this does to the concept of citizenship and what it does to Indian democracy. Let's at this point widen our discussion, because I want to put to you certain critical aspects of the NRC process itself and ask you whether they are legitimate, legal and fair. To start with, the NRC process required every resident, every person living in Assam to himself or herself prove they were citizens of India. The onus of proof devolved on them. But millions of these people are poor, they're illiterate, they're rural, and they do not have the documents required. Yet if you don't have the documents, you're deemed to be a foreigner. So ab initio, was this legal and fair?
I would say it was grossly unfair. You see, number one, Assam has a unique geography. Every year Brahmaputra changes its course and thousands of villages, get eroded. We get floods and documents get destroyed. So just because somebody is not able to produce a document, you say he is not a citizen. He is a citizen, but document is not there with him. Now in this whole process, what we are doing, we are overemphasizing documents. Now here I have to tell you, the courts again have been giving inconsistent decisions. Just to give you one example. Having a passport of another country, in one case the court said that means you are not Indian citizens. So in Abdul Hafiz Qadir, they said if somebody has a Pakistani passport, that does not mean he is necessarily Pakistani. In another case, they said if he has a Pakistani passport, then he is a Pakistani citizen. In a third case, again they went back and they said having a passport does not mean anything. In another case, they said just because your name is there in the voter list, that does not mean you are a citizen. So sometimes you emphasize documents, sometimes you negate your own documents.
So on the position of documents, the court has taken contradictory stands at different times.
Yes.
But here, the real unfairness and injustice is when you're talking about poor people and illiterate people, and as you correctly pointed out, people who are regularly flooded and their houses destroyed by the Brahmaputra, you're expecting them to have documents. Loads of people like me, and perhaps you, may not be able to easily find our birth certificate. It may not have been kept. As you get older, you don't know where it lies. But you're expecting poor illiterate people, whose homes are often regularly flooded, to provide certificates, and they have to be precisely the sort of certificate you want, not anything else that proves birth or parentage, but only the certificate you want. That you're saying is grossly unfair.
No, let me give you a little bit of details. You are not asking a document which is readily available with me. You are saying I have to produce a pre-1971 document, 1951 NRC, which Guwahati High Court said was not rightly done. It is not a public document. You are asking people to produce pre-1971 bank accounts. How many people had bank accounts at that time? We should thank Prime Minister Narendra Modi for so many people having bank accounts.
You're asking people to produce documents that are not just sometimes 40 years old, sometimes over 60, 70 years old. And these are poor people whose homes are often washed away. They are illiterate people who probably don't keep documents, yet you're asking them to produce them. And if they don't produce them, they're deemed to be foreigners.
So first you produce those pre-1971 documents, what are called legacy documents, list A, and then you produce a post-1971 document, list B documents, and prove the linkage, then only your name will be included.
Now, as a result of this, and we found this out when the outcome of the NRC was known, we find that people have been refused inclusion in the NRC because their name is spelt differently in different documents. Brothers have been included and sisters excluded. Sometimes parents have been included and siblings excluded. We've even got cases where close relatives of a former president and serving MLAs have been excluded. Does that suggest that this whole process of the NRC was simply misconceived?
Misconceived and very badly implemented. Very badly implemented. Now, if you have your own army officers, police officers, government officers, even election officers and people who are involved in the NRC process, their names have been excluded.
So beyond the unfairness and beyond the illegality, it's also been inefficiently handled. It's been badly implemented.
Yes. If Vinod Rai has been there, he would have calculated the human cost and the presumptive losses which have come to India because of NRC. And I am sure it would have gone to more than 1 lakh crore.
Let's now come to the consequence of the NRC. Just over 1.9 million people have not been included. Their cases will now go to foreigners' tribunals. At the moment, there are 100 such tribunals, but the government has said 200 more will be created. So 1.9 million cases will be handled by 300 tribunals in a fixed time frame that cannot exceed 6 months. That means each tribunal will handle 6,333 cases. And that in turn means each tribunal has to handle 35 cases a day, including working on Sundays. And that in turn means each tribunal has to handle 1.5 cases per hour right through the 24 hours of the day, including working at night. And I want to ask you a simple question. Is that doable or is that laughable?
Justice hurried is justice buried. It is humanly impossible to do it in this short span of time.
And yet that is what is required.
I'm sure they are going to amend the law and extend the time.
But as yet they haven't. Therefore, let me raise with you a second problem with the tribunals. It's to do with the quality of the tribunals. I discover that these tribunals do not necessarily have to be headed by judges. They can be headed by ordinary lawyers. In some cases, they can be headed by bureaucrats. And often those could be bureaucrats without legal experience, without even very much training. Is it right, therefore, that these at best quasi-judicial bodies should be handling something as critical as a human being's citizenship?
These are kangaroo courts, and it is wrong to call them quasi-judicial, because as you know, originally these tribunals were constituted under the Foreigners Act 1946. Now, it is a colonial piece of legislation. We are talking of citizenship of post-independent India. And originally the law said, when these tribunals were constituted in 1964, that they will have retired additional district judges, people who have judicial experience. Then now they said that lawyers with 10 years experience and 55 years of age. I saw another advertisement, and they have recruited on the basis of that advertisement more than 210 people with 7 years experience. They say even civil servants, retired civil servants can also be members. Then these members, their services can be dispensed with. So 19 members of foreign tribunal services were dispense with because their record in terms of declaring people foreigners was poor. So initially they were given 2 years contract, now they are given 1 year contract. There is no security of tenure for them. The government is pressurizing them, and they are appreciated if they declare more people as foreigners. Who is the highest wicket taker is the conversation in Assam.
You're saying three very important things that I want to point out for the audience. First of all, you're saying a colonial era law has been used to create foreigners' tribunals, and it's inappropriate for independent India to have fallen back on this. Secondly, you're saying the qualifications required for the person who heads the tribunal have been steadily whittled down, and you've come to the point where even retired civil servants who may have no legal understanding and experience can head tribunals. And most importantly, you're saying that in fact these people, when they're appointed, can be dispensed with, so the government can put pressure on them. In other words, instead of acting independently, they'll be bending the knee to the government.
They're not independent at all.
In which case, let me then come to the next critical question about these tribunals. It's to do with the quality of their decisions. Now, Rohini Mohan has analyzed 500 tribunal judgments, and she's come to the following conclusion. She says over 80% of the people on trial were declared foreigners. As you pointed out, therefore, there's a huge inclination to declare people foreigners. 80% of the people on trial were declared foreigners. They were all Bengali, and they were overwhelmingly Muslim. Secondly, she points out the burden of proof is on the accused. In 78% of cases, the orders were delivered ex parte without the accused being heard, that is to say. And it seems different tribunals followed different procedures. There isn't even a uniform procedure. Now, as an expert in law, does that suggest fairness?
Karan, someone who has taught criminal law and constitutional law for so many years, I feel really very bad to see how these tribunals are working, how notices are issued. Even the law under which they are working, it says that they shall communicate the main grounds, and their notices are X plus so many people come and appear before the tribunal because somebody doubts your nationality or your citizenship.
No grounds communicated.
No grounds. When police gives evidence, they are bound by that evidence, but witnesses are giving evidence, they may stop that evidence. These tribunals are not open to public. You see, Constitution talks of tribunals. So in Constitution, they refer to all kinds of industrial tribunal. You have a green tribunal, you can have tribunals on land. Why you have tribunals under an executive order? Why tribunal proceedings are secret? If these are quasi-judicial proceedings, bring more transparency in their order.
And there's no transparency here. Yes. And all the problems you mentioned are exacerbated by the fact that sometimes the tribunals are headed by retired civil servants who have no legal training and therefore do not have the capacity to work out whether evidence is admissible or not. They'll simply go by their instinct or by their bureaucratic training, which may not be legally justified.
Yes, no due process is being followed.
Now, at the end of the day, people rejected by these tribunals, and we could be talking of lakhs and lakhs of people, we simply don't know how many will be rejected, still do have recourse to a High Court appeal and a Supreme Court appeal. Doesn't that mean that their future will be hanging in an uncertain way, like a sort of sword of Damocles over them for years, if not decades?
I'm sorry, but who in India can afford High Court and Supreme Court? Look at the fees which lawyers charge. Now, even for matters like this, if you have to pay 70,000, 80,000 people, these poor people, destitute people, unemployed people, they don't have money to engage lawyers.
So in their case, the fact that theoretically they can go to the High Court or the Supreme Court is only a theoretical possibility. They simply don't have the money to avail of these steps.
Just like we say that even aliens in India have right to life, right to dignity, but we know even our own citizens how much right to life and liberty they have.
So you're saying something very important. When these foreigner tribunals decide that people are foreigners, and we've already discussed how imperfect the tribunals are, and how poor will be the quality of the person presiding over them in many cases, that outcome will be a death knell for most people, because even though they may theoretically have recourse to high courts and supreme courts, they don't have the money, and therefore they can't pursue it.
It's the civil death of our own citizens.
The civil death of our own citizens. Finally, assuming some people do go to the High Court and Supreme Court, there will come a stage when the process will end. What will happen to people who at the final stage are deemed foreigners, deemed illegal in India? Clearly, Bangladesh has already told us they're not going to accept them. So what sort of life would these people have in India? Would they have access to welfare? Would they be permitted to own property?
See, as per law, they are to be put in detention centers. So about 1,335 people are in 6 detention centers we are having. But out of this, about 1/3, 335, the Supreme Court said they should be released on bail because they have been in detention centers for more than 3 years. So these people can't be put, that big number can't be put in detention centers. We are hearing a detention center is coming up in West Bengal, is coming up in Maharashtra, is coming up in Karnataka.
The government, according to some reports, plans to create 10 more.
Yeah, so even if they create 10 more, in 6 you are having about 1,300 people. So you create 10 more, still it won't accommodate lakhs and lakhs of people. These people will eventually be released, but when they will go for work, they will not be given minimum wages. They will be denied other welfare schemes, and of course they cannot buy the property. So you will have people within India who will live in subhuman conditions.
Now, as you said, the law does permit the creation of detention centers, but is it in keeping with the spirit of the Indian Constitution, or does it breach the spirit of our Constitution?
It definitely is in violation of the spirit of Indian Constitution, because Indian Constitution adopted civic nationalism. It doesn't believe in ethnic nationalism. Indian Constitution gave citizenship liberally to everyone who takes birth in India. Most of the people we are having who have been excluded are people who were born in India. What were their parents is a different question. But we are denying them citizenship.
And now we're going to put them into detention centers, which some people, perhaps exaggeratedly, have actually called concentration camps. I don't mean to bring in any Hitlerian associations, that would be invidious to do, but the simple condition of a detention center is perhaps comparable to that, because it's not going to be a pleasant life.
As per government of Assam's own calculations, more than 25 people have committed suicides in the detention centers.
Let's at this point come to what's called the Citizenship Amendment Bill. The government, it seems, is determined to pass it in Parliament during the winter session. Now, the Citizenship Amendment Bill provides fast-track citizenship for Hindus, Christians, Sikhs and Buddhists from Pakistan, Bangladesh and Afghanistan who seek sanctuary in India. But explicitly, it excludes Muslims. In a country that calls itself constitutionally a secular country, where discrimination according to religion is constitutionally impermissible, do you think the Supreme Court will strike this down if Parliament passes it?
Difficult to say, because Supreme Court, if it refers it again to the Constitution bench, and that matter will come up before the court after 3-4 years, but it will be a clear violation of Article 15, which prohibits a state from making any law which discriminates only on the basis of religion.
But your feeling as a constitutional expert is that this is a clear violation of Article 15.
I am absolutely clear about it.
And therefore, it's unconstitutional.
Absolutely.
So if the Supreme Court refers it to a constitution bench, that may be technically the right thing for the Supreme Court to do, but it's also a way of passing the buck and delaying taking any decision.
Yes, of course.
So ipso facto, if I can use the phrase by the back door, this will go through.
It will go through, or it is already there, Karan. We are not appreciating that in 2015 and 2016, already there have been rules which have been made, and these rules allow that people who have come from Afghanistan, Bangladesh and Pakistan, if they are Hindus or Christians or Parsis or Buddhists or Jains, they will not be treated illegal migrants.
So already through the rules, effect is being given to implementing the Citizenship Amendment Law.
Yes, those who came by 31st of December 2014, we are already protecting them. And that's why I say this whole NRC exercise with a cutoff date of 25th March 1971 is farce.
It's no secret that the logic behind the Citizenship Amendment Bill is to ensure that Hindus who get excluded from the NRC in Assam find a way of becoming citizens. But then doesn't that convert the NRC, which was intended to be a secular exercise to identify illegal foreigners regardless of their religion, has been converted into a communal exercise which now only seems to target Muslims?
Yes, the Assam subnationalism was not communal. There were concerns that Bengalis are coming, their culture, their ethnicity is in danger. You know, if you have 48% Assamese in Assam, some of these concerns may be genuine. We are giving a communal color to it. They were saying anyone who is non-Assami is an outsider.
We've changed that to anyone who is non-Hindu.
Non-Hindu.
In fact, non-Hindu, non-Sikh, non-Buddhist, non-Christian.
Yes.
In other words, anyone who is Muslim.
Anyone who is Muslim is to be excluded, and this law is like law of return of Israel, that India is the home of Hindus. And this proves the two-nation theory which Savarkar has been talking about.
Except the government doesn't realize they're doing it. But that is precisely what the implication of what the government is doing happens to be.
Yes.
Now, in the mid-90s, the Supreme Court made a concession so that Buddhist Chakmas in Arunachal Pradesh could be given Indian citizenship because of the length of their residence in the country. Cannot a similar concession be given to Muslims who've resided in Assam, not just for years but for decades, to be deemed Indian citizens?
I think so. Chakmas were Bangladeshis who came from the Chatgaon Hill Tract. Some 5,000 people came, then subsequently the number went up to 65,000 or so. So initially they came to Assam, one group of families, then they moved to Arunachal Pradesh, and when we changed our law, then they claimed citizenship, because our law as it stands, section 6A of Citizenship Act, it said anyone who came before 1st of January 1966 and is an ordinary resident of Assam shall be deemed to be Indian citizen.
The problem was that by then these people had moved to Arunachal.
So Guwahati High Court denied them citizenship. Supreme Court in 1994 upheld this denial of citizenship. Then in 1996, National Human Rights Commission went to Supreme Court, said that these Chakmas are being discriminated, there are quit notices against them. There was ASU-like organization, all Arunachal Pradesh Student Union, and Supreme Court then came to the rescue of these people and asked Arunachal government and the central government to give them citizenship by registration. I think the same kind
because of the length of residence in India.
Yeah, and so I think same kind of benefit is to be extended to leftover people from the NRC.
It's very important, this point, because the situation that Chakmas found themselves in Arunachal Pradesh was very similar to the situation that Muslims in Assam who are going to be deemed foreigners find themselves in. And just as the Supreme Court was prepared to make a concession to say because of the length of their residence, they should be deemed citizens by registration, a similar concession could be given to Muslims who've lived in Assam for decades. And again, the court could say because of the length of your residence, you can be deemed citizens by registration. That's the point you're making.
Yes.
My last question. Many members of the BJP, Manoj Tiwari in Delhi, Kailash Vijaywargiya in Bengal, even Himanta Biswa Sharma in Assam, are all demanding that the NRC exercise should now be carried out nationwide. Do you believe the experience of the exercise in Assam and all the constitutional questions it's raised about the way it breaches the Citizenship Act, the way it restricts and diminishes the concept of citizenship, and the way it damages our democracy, does that justify carrying out an NRC exercise nationwide?
There is one positive thing of NRC exercise. It proved that fiction and facts are different. The kind of narrative which we had made that we have 5 million, we have 10 million illegal migrants has been busted now. Now people who are themselves criticizing, BJP leader Hemant Biswa, Sonowal and others, they are saying this exercise was wrong, we don't trust it, and they want to repeat in the rest of the country. I can't say much about it, but in the meanwhile...
Can I interrupt there? You're saying an interesting, somewhat ironical thing. The NRC in Assam has busted the myth that there were 5 or 10 million illegal people. It turns out at the most it's 1.9, and that figure will diminish as well. And therefore, if an NRC were to be carried out nationwide, ipso facto, it would follow the myth that there are millions and millions of illegal people all over India would also be busted. And that's a possible reason for carrying it out, because the myth that there are illegals will be busted. But on the other hand, given what it does to individuals, the way it diminishes the concept of citizenship, and the way, as you pointed out, it damages our democracy, is it fitting that we should carry out this exercise all over the country?
Not at all. What I am trying to say, that the positive thing is that when you created a narrative and Supreme Court carried away by that narrative, that's why you have some of the problematic judgments from the Supreme Court leading to NRC. We are not realizing that in the meanwhile Bangla economy is doing very well. In last few years, while our GDP increased by 117%, their GDP increased by 187%. China's GDP increased by 177%. So their economy is improving. The census data itself is showing decline from migration from Bangladesh. In fact,
so what's the point you're making?
The point I am trying to make, that between 2001 to 2011 census data, which is now out, is saying that outsiders who were 0.6% in 2001 are now 0.4%. So people are not coming from Bangladesh to India. In fact, we are having some 11 million people, illegal people, who are in Bangladesh, and Bangladesh is fifth largest remittance sender to India.
I take your point. First of all, you said, and I'm just getting you to repeat it, that under no circumstances does the experience in Assam justify extending the NRC nationwide.
Correct.
That's correct. Yes. And the second thing you're saying, which again is an ironic point, that these days, because the Bangladesh economy is growing at a faster rate than the Indian economy, you have illegal immigration not from Bangladesh to India. Yes. It's the other way around. It's Indians going to Bangladesh because the economic conditions, the job conditions are better on the other side of the border.
Yeah, 2012 we got $3.7 billion remittance from Bangladesh. It is the fifth largest contributor to Indian remittance.
What a very interesting fact to end on. If nothing else, that alone should make people think up very carefully about all the issues we've discussed. Professor Mustafa, a pleasure talking to you.
Thank you so much.
To receive instant updates on all videos from The Wire, click the subscribe button and hit the bell icon. Pay to support independent journalism. Click the link in the description and choose the amount you want to pay.